Hello, I'm Brad Green, and I'm one of the attorneys at King and Green. And today I wanted to talk to you about one of the things that we do here at the firm, and that is handle appeals. And most people understand that an appeal is something that takes place after there's been some type of final ruling, final order from the trial court. And the trial court that most people are familiar with in Alabama is the circuit court. That's where divorces are tried. That's where car accident, personal injury cases, contract disputes, real estate disputes, that's where all those are resolved. Some of those disputes are resolved after a bench trial before the judge, and the judge issues the decision. And some cases are handled and tried before a jury, and the jury issues a verdict, a judgment for one side or the other. And then after there has been a judgment entered, either by a trial before a judge or a trial before a jury, each side has 30 days in circuit court to file what's called a post-judgment motion, asking the trial court to change something or set aside the previous order. Now, in Alabama, you have 42 days to appeal a decision, a final order from the circuit court. But if somebody files one of those post-judgment motions, which they often do, that stops the time running on the appeal. And then the trial court must rule on that post-judgment motion within 90 days from the date it was filed. And again, the post-judgment motion in circuit court must be filed within 30 days of the final order. If the trial court doesn't rule on the post-judgment motion within 90 days, it is deemed denied by operation of law upon the expiration of 90 days. But most of the time, the trial judges will rule on the post-judgment motion, and they'll have a hearing where the lawyers get to make arguments and cite law to the trial judge, asking him or her to change something. But once there is a ruling on the post-judgment motion, or the 90 days is up, the 42-day period to appeal starts running again. And a party who thinks that something went wrong, there was a legal error made in the trial court, can file the appeal, and they file a notice of appeal, and they pay a docketing fee, and then they have to pay the court reporter. If there was a court reporter that took down the transcript of the trial, they have to pay that court reporter an estimated cost for transcribing the case. And then the clerk of the trial court and the court reporter, if there was one, start compiling the record. And they have to do that within a certain period of time. When they finish compiling the record, you get bound volumes that look like this. Each one is about 200 pages long. And so if you had a week-long trial, you could have very easily 10 to 20 volumes of the transcript of the trial. Sometimes if you had a short trial, maybe just a few hours or a day, it might be a single 200-page volume, or maybe just one and a half. In addition to the transcript of the trial, the clerk of the trial court will also make copies of everything that was filed by the parties, the pleadings, the motions, temporary orders from the court. All that's put together in chronological order, and it's given page numbers. And so then, when the clerk has finished compiling the record, they file a notice to the appellate court saying the record is complete, and they send that record to the litigants. And so the party that has filed the appeal is called the appellant. And from the date the record is completed, they have 28 days under Alabama's rules of appellate procedure to file their brief. They can get a 1-week extension, so the maximum would be 35 days that the appellant, the person appealing, would have to write their brief. And their brief looks like this. The appellant's brief will be in blue, and it will be bound like this. It will have certain sections on the inside, like a table of contents, a table of the authorities, the legal authorities that you cite, a summary of the facts in the case, a statement of the procedural posture of the case, how it came to be here, and it will cite the law and make arguments applying the law to the facts in that case, and it will ask the appellate court to reverse the trial court in some way. Now, after the appellant files their brief, the other party that prevailed, in essence, at the trial court is known as the appellee. And the appellee has 21 days to file their brief in response, and they can get a 1-week extension. So that's a maximum of 28 days for the appellee to write their brief, and it'll have a red cover on it. And then after the appellee files their brief, the appellant gets one more crack to make an argument, and they get to file a reply brief. And again, it has a gray cover, if you can tell, where their first brief had a blue cover. The appellant's brief would be in red. But this reply brief gives the appellant an opportunity to respond to what the appellee said in their brief. They have 14 days to file their reply brief after the appellee has filed theirs. And then that's it in terms of the arguments, the written arguments that you get to make to an appellate court. There'll be those briefs, and then the record and all the exhibits and everything that was entered in the trial court, the transcript of the trial, and the briefs go down to Montgomery. And there are 3 appellate courts in our state system. The Alabama Supreme Court is at the top, and below it are the Alabama Court of Criminal Appeals and the Alabama Court of Civil Appeals. And obviously, criminal cases go to the Alabama Court of Criminal Appeals, and then the Alabama Supreme Court can review and does review decisions of the Alabama Court of Criminal Appeals. Now, on the civil side, some cases go directly to the Alabama Supreme Court. Civil matters involving more than $50,000 in controversy in certain other limited areas are part of the original jurisdiction of the Alabama Supreme Court. But a lot of cases, including all cases involving domestic relations or the juvenile courts, so divorce, child custody, child support, those issues, go directly to the Alabama Court of Civil Appeals. Each of the 2 lower appellate courts each have 5 judges that are elected statewide for 6-year terms. The Alabama Supreme Court has 9 justices that are elected for 6-year terms. Sometimes you can get a decision from the Alabama Court of Civil Appeals, and you can request the Alabama Supreme Court to look at it and review it. And that's called filing a petition for a writ of certiorari. Some cases, the Alabama Court of Civil Appeals, like I said, gets directly, and the Alabama Supreme Court doesn't have to look at the decision of the Court of Civil Appeals if it doesn't want to. And so if they grant the writ for certiorari, then they bring the case up and review what the Court of Civil Appeals did, and they can reverse the Court of Civil Appeals or they can affirm it, but that's generally the process. Now, it's rare, but occasionally in Alabama, you can have what is called oral argument on an appeal. And that is not where there's another trial. There's no testimony that's given. The only thing they review is the record, but sometimes they give litigants an opportunity to come down to Montgomery, and in a very short process that is timed, you get to make oral arguments to the appellate court. Generally, what that involves is you start to try to make a statement, and the judges or justices start asking you questions and interrupting you. And you have a strict time limit, and the lectern the podium that you're standing at in the court has lights on it. It has a green, a yellow, and a red light. And you only have 30 minutes on average to make your argument, and when there's only a few minutes left, it will change from green to yellow, and then it will flash red, and you must stop. So we don't have oral arguments as much in Alabama as we used to. Recently, we had one before the Alabama Supreme Court, and that was very unusual for the Alabama Supreme Court to grant oral argument in a civil case. What oral argument you do have before the Alabama Court of Criminal Appeals, the Alabama Supreme Court, by and large, does involve criminal cases. So, but if there is oral argument, once it's concluded, or if there's not oral argument, once the briefs have all come down and the evidence and they've been reviewed, the court makes a decision, whether it's the Court of Civil Appeals or the Alabama Supreme Court, and there is a vote taken among the judges or justices. Again, on the intermediate courts, they're called judges. On the Supreme Court, they're called justices. But there's a vote taken, and the majority wins. And the senior judge or justice in the majority gets to decide who writes the opinion, and the senior judge that is in the minority can write a dissent and choose who that dissent is written by, or they can write it themselves, and other judges or justices can join that dissent, or they can write their own individual. But you get a decision that is in writing, and it is called an opinion, and many of those opinions end up getting published in our reporters. And when you see, commercials for lawyers, or you see television dramas or movies involving lawyers, all those big formal-looking books that resemble encyclopedias, generally that's what they are. They're the reporters, and that is the published appellate decisions that serve as precedent in a specific state or jurisdiction. And what you do, those decisions spell out what the case was about, what the law was, how the facts were applied to the law, and the decision, the holding of the appellate court. And then other lawyers can look at those cases in the future and say, well, I have a case very similar to this or just like it, and the Alabama Supreme Court said in this circumstance, this is what must happen. So you cite precedent to other courts, to the lower courts, saying this is what the law is in Alabama on this issue as decided in this appeal. So appellate work is different from trial work. And of course, we do a lot of trial work. But the appellate work we do is really focused on a lot of legal research and searching through other cases, and sometimes very old cases, sometimes very obscure cases, trying to find points of law that support our client's position. And we make those arguments to the appellate court, and then they give a decision. And sometimes if they reverse the trial court, they reverse it and they give instructions to the trial judge to change something about the order. Or they can affirm the trial court's decision, which means it stands. So there's lots of other things that come into play in appeals. If you're appealing a money judgment against you, to file the appeal, sometimes you have to post a bond saying that, if I lose, I posted the money saying that I'm not delaying the recovery of a judgment because I'm posting a bond for in excess of the amount that is a judgment against me. In divorce cases or child custody cases, you don't post a bond. You just have to pay fees and say if there are any other court costs that you will be responsible for those court costs. So that's a little bit of an explanation of the appellate process in state court in Alabama. It's something that we do a lot of. We represent individuals and businesses and municipalities in appeals. And appellate work is very challenging, but it can be a lot of fun because you're representing people in very serious cases, and you're making arguments that are going to be thoroughly looked at, you hope, by our appellate courts, and that a lot of attention will be paid to what needs to happen in a case. The only other thing that I'll say is it is hard to win an appeal at any level in any jurisdiction, and that is because our system of law and that we inherited from the English system is that there is great deference given to the trial courts and the decisions they make. And so the appellate courts will generally not reverse a trial court just because they think they would have made a different decision or they would have come to a different verdict than that jury. The appellate courts will only reverse if they find an error in the law. And that's important to remember. It's very hard to win an appeal because of that. So I hope that helps you understand a little bit about the appellate process and what we do here. If we can ever help you in a situation where you need counsel on appeal, we would be happy to help.